Construction site cases in New York have a unique protection, and it protects a lot of people who work on construction sites, but not everybody. And the law that governs what happens on construction sites to protect individuals working from a height is called Labor Law 240. Many people call this the scaffold law. Labor Law 240 protects construction workers who are working from a height or are subject to a gravity-related event. Many people who call it the scaffold law, I think it's a misnomer because it's much more than just scaffolds. I personally call it PIL, P-I-L. It's the Preventable Injury Law. Why is it the Preventable Injury Law? Because it prevents preventable injuries. Labor Law 240 was crafted to protect construction workers because construction workers, by the mere fact that they are often working from a height, are subject to increased risks and dangers, and anybody who falls from a height or has something fall on them from a height is subject to catastrophic injuries. So New York State instituted and created this law to protect a special class of workers who are subject to enhanced risk of injury. And what happens as a result of this law? New York happens to be one of the safest places to work in the entire country because there's only 2 other states that have a similar law, and each of those states also have very safe places to work for construction workers. You would think with all of the construction in New York City and Buffalo and Albany, Saratoga or Syracuse, with all of these high-rise buildings, there would be many more significant injuries, but there really aren't because how Labor Law 240 works, and let me share that with you today. Labor law, or what I call the Preventable Injury Law, prevents preventable injuries because it requires and puts the burden and obligation, something called duty, and you want to learn more about duty, you can look at another video that I did about the basic elements of personal injury law. But one core element of personal injury law is duty, responsibility. And Labor Law 240 is a statute that puts the absolute duty and responsibility on the owner and general contractor of a construction site, period. They must provide safety devices that will prevent injuries from anybody working from a height or subject to things falling upon them. In order for an injured worker or as their lawyer to be able to raise Labor Law 240, all that is required is to be able to show a few elements. Number one, the injured person is within the classification of type of worker that this law covers. Number two, that they were engaged in a defined activity that the law covers. And third, that there was a safety device that was not provided that would have prevented the exact event or injury that occurred. Importantly, there may be other safety devices that were provided, and there may have been safety devices that were even being used at the time. But if we can show that there was a safety device that could have been provided that would have prevented the event or the injuries, you satisfy Labor Law 240, the Preventable Injury Law. And this is why it's so important, because this is a decision that's not made by a jury. Generally, such a decision is made by a judge. And once a judge has ruled that the owner and or the general contractor has violated Section 240 of the labor law, the Preventable Injury Law, then as a matter of law, which means automatic, the judge has ruled that the owner and general contractor are 100% responsible for all of the injuries that the injured construction worker suffered. Why is that important? That means they are not allowed to raise as a defense that the injured worker did it to themselves or anything called comparative fault. There's no comparative fault when it comes to a labor law 240 case. The owner and general contractor are 100% responsible for 100% of the damages. But let me highlight for you and read the exact law because there are many nuances with respect to Labor Law 240, far more than I can get into now. So I just want to give a broad overview. And Labor Law 240 reads very simply, first it defines who it applies to. All contractors and owners and their agents. So it's all contractors and all property owners and their agents, except, and it's the only exception, owners of 1 and 2 family dwellings who contract for but do not direct or control the work. Okay? So it's the owners and general contractors of any construction site, as long as it's not a 1 or 2 family home, and frankly there are some exceptions to that, which I'll come back to in a moment. But it's all contractors and owners of properties where construction is being done. And this is the defined work in the erection, demolition, repairing, altering, painting, cleaning, or pointing of a building or structure shall furnish. So those are the activities that are covered. The erection, demolition, repairing, altering, painting, cleaning, or pointing of a building or structure. So you may say, well, doesn't that cover anything? Everything. It doesn't. What it does not cover is routine maintenance. So there are a lot of fact-specific patterns as to what is the underlying activity the construction worker or the activity that the work is ongoing that is being performed and whether or not it qualifies. Don't confuse when I say construction, it need not be new construction. It could be a rehab of a building, or it could be something that's going on in the building of a building that's been in place for dozens of years, and they're putting in, for example, an entirely new air conditioning system up on the roof. That would fall under Labor Law 240 because that's not mere maintenance. When we're engaged in significant activity, construction type activity, that includes the erection, demolition, repairing, altering, painting, cleaning, or pointing of a building, then we have a defined activity. So what is the obligation on the owner of the property and the general contractor? And I importantly say and, it's not or. They both must provide this. And if they fail to provide what I'm about to read, they are both responsible. So it says, they shall furnish or erect or cause to be furnished or erected for the performance of such labor, scaffolding, hoists, stays, ladders, slings, hangers, blocks, pulleys, braces, irons, ropes, and other devices, which shall so be constructed, placed, and operated as to give proper protection to a person so employed. So the magic words are other devices, because if a safety device that's not enumerated there, but there's another safety device, would have prevented the fall or something falling, and you're engaged in the enumerated activity, then there's absolute responsibility on the owner of the property and the general contractor because they failed to give proper protection. Period. The law requires proper protection be provided to construction workers because construction workers are exposed to ultra hazardous activities oftentimes. One can fall 3 feet and be catastrophically injured. It need not be a very high or long fall to have a very serious injury. So the burden is placed on the general contractor and the owner, and the construction worker often doesn't work directly for the general contractor. And the way these cases generally play out is that a subcontractor, and here's the principle behind the law. You may ask, why should the owner and the general contractor have the ultimate responsibility to make sure there are safety devices on their property? Well, the answer is simple. Those who control the work control the safety. Who's in a better position to control the work on their own job site? The owner and the general contractor. The subcontractor, their motivation is to get in and get out and do the job as quickly and as cheaply as possible. And they aren't necessarily so concerned about the safety of the work environment. Their sole consideration is to get the job done effectively and efficiently pursuant to the contract, but not concerned about protecting generally the construction workers. So the party that's most in the best position to make sure their subcontractors provide safety devices to all the workers on the job site is the general contractor and the owner. So it requires the owner who contracts with a general contractor to make sure that they guarantee a safe work environment by providing all the necessary safety devices, and the general contractor, when they contract with their subs, it requires them to incorporate into those contracts safety devices for anybody who is working from a height. Now, the way these cases often play out is an individual, a construction worker who's working for a subcontractor. Let's just say it's an individual putting up sheetrock. They're asked to put up sheetrock on a 20-foot high wall, and they're provided a 6-foot scaffold. Well, the 6-foot scaffold will take them up to maybe 15 feet. But for the last 5 feet of sheetrock that's necessary to go up, the obligation is on the general contractor and the owner to make sure there's adequate safety devices, in this scenario, scaffolding or a scissor lift or some type of safety device that the construction worker can do the work at such a height safely. But if they don't provide it, the subcontractor doesn't walk off the job. The subcontractor says to the worker, all right, throw a ladder on top of the 6-foot scaffold, an extension ladder, and work your way up there. That violates Labor Law 240. So if while that construction worker is at the top of the ladder, and if the scaffold moves in some way and the ladder comes down and he falls and gets seriously hurt, that individual has 2 claims. First, because he is working, he's entitled to workers' compensation. If you want to learn all about workers' compensation, watch another video I did that talks about the interplay between workers' compensation and personal injury cases. But the first claim that he's entitled to is all of his workers' compensation benefits, which is his economic loss for his lost wages and payment of medical bills. That flows from the subcontractor, who is his employer or her employer. But he is also entitled to a claim against the general contractor and the owner of the property for failing to ensure that there were safety devices to protect him from height or gravity-related events during his job. So that is called a third-party case. Then he can commence that action, which what he'll be seeking to recover is not just his economic loss, but also his pain and suffering. Now, I want to circle back to the exception of 1- and 2-family homes. Oftentimes people immediately think, and when I say people, I'm specifically referring to lawyers, they may ask a potential client, so where did your construction event occur. And as soon as they hear, oh, a single family house or a two-family house, they may think, well, then Labor Law 240 does not apply. That's not true. If the owner of the one or two family house is acting as the general contractor and directing the work, Labor Law 240 would apply, and they have the obligation just to provide and make sure on the job site that they are providing a safety device that protects people working at a height. Another exception for a one or two family home is if the homeowner also has a business contained within the home, because what the exception allows one or two family house or homeowners to avoid the automatic responsibility of Labor Law 240, but it's not intended to exclude business owners. So if a business owner who runs their business out of their house and their house doubles as also their office, they too would be subject to Labor Law 240, the Preventable Injury Law. So it's quite fact specific as to whether or not there's a viable claim against a one or two family house homeowner, but a general contractor, if the homeowner hires a general contractor and the general contractor hires a sub, they don't get the benefit of the exception of the one or two family exception from Labor Law 240, because the exception only goes and extends to homeowners. So that's a broad overview of Labor Law 240. It's a very important law that protects all of our construction workers, and I hope that was insightful for you.